Hi, True Crime Grapevine fans. Okay, it's me, Patti Lee. We are up to this is the 26th week of the True Crime Grapevine. And this is the Lori Vallow-Daybell cult mom case. This is out of Idaho. Idaho's a big Mormon community as long as with Utah. And Lori Vallow and Chad Daybell developed their own church. What is it? The Church of the Firstborn, or the Firstborn Church. They developed that out of their Mormon theory. So I am pouring some Fresca. Why? Because Mormons don't, did you know Mormons don't drink? And they don't, and when they do drink sodas, they don't drink caffeine. Caffeine is bad. So I did drink mom water because, you know, and there was a Karen, because she's kind of a Karen. But, you know, I want to be true to her Mormon roots. So we're going to drink Fresca for Lori Vallow. Yeah, that's right, my little bee glass. Okay, so what's up with Lori Vallow? So we've got a couple of updates in the Vallow case. Let's unpack our case. Number one, Lori Vallow was in court and she thought things, I don't want to say she's nuts because I want her to go to trial, but she was kind of like this. It was odd AF. So she's laughing and she's looking into the courtroom behind her and like, kind of like giggling at somebody back there. And Nate Eaton and the East Idaho News were there documenting. And when she got into the car, she gave this like, seriously, like a red carpet sort of getting into the, like, I'm here. It was odd. So yeah, she's going on trial for murdering her 2 children and Chad's wife in Idaho, as well as, so here's the complication and why they were in court. As well as, so there's insurance money, so grand theft of insurance, which could be considered an aggravating factor, and conspiracy to do these things. Conspiracy to murder, as well as conspiracy to commit grand theft through the insurance fraud. And in different states, there's different ways of writing indictments. And usually you write what we would call a clean indictment, which would be the counts would all be separated. So you would have a count for murder for each child, the conspiracy to murder the person that she didn't directly kill herself but was known to kill, which would be Chad's wife, Tammy Daybell. And then you would have fraudulent counts for the grand theft of insurance for Tylee. She was, and probably, and also JJ, because, and then Chad would have his own insurance fraud for his wife. So, but those would all be extra counts. And the defense is saying, okay, well, you have to send this back to the grand jury because this seems very confusing because this is a death penalty case and these are aggravating factors, having these extra crimes in there, and they are written with a conjunction. And if you're old enough, you remember conjunction, junction, what's your function? It's like, what was it? Tying up words and phrases and dun dun. Okay, so like and but nor. Remember and but nor will get you very far in Schoolhouse Rock? Okay, so they're written with and. 2 counts of murder and grand theft. 2 counts, you know, whatever. So the defense was saying, look, we can add language into the jury instructions to explain this. The Idaho, specifically Supreme Court, has not, like, the in Idaho, unlike other states. So if you watch true crime or true crime. If you watch Crime Talk with Scott Reich, or other lawyers, they will explain to you in other states, you can't write counts like this. They have to be separate. And so the cure legally for this is to go back to the grand jury and present everything again, but separately. What I don't understand is why you can't go back to a grand jury. So what a grand jury is, it's more than 12 people. It's a bunch of people. They meet once a month or once a month or once a week. Now, I believe it's once a month for the whole year sometimes. It depends on the area. But a grand jury is a larger group of people who meet once in a while to hear whatever the county or the state has going on. There's federal ones too. So there's, if you don't know anything about law, it's called home rule. We start with the smallest. So there's like municipalities, then there's counties, then there's states, then there's like regions federally, and then there's like federal completely, which ends up being like the Supreme Court. So, and the laws and rules and procedures in court can be different depending on what state you're in, or if you're in federal court within a state. And how the law is interpreted is based on what has happened in that state and type of court, either state or federal, before. It's the law. The reason lawyers have to go to law school, it's really confusing and it's very specific. Even though there's generalities, sorry, there's the dyslexic detective in me. Even though there's generalities, there's specifics to each state. So apparently in Idaho, it's not like other states, and it's less specific about how you write these things, but it could still be confusing to the jury. That could cause a problem later on. We don't know how this is going to be cured. Will they take it back to the grand jury, or will the judge say, okay, I will try to do some ruling on this? That's what this hearing was about. And we didn't end up with a judgment from Judge Boyce, I do not believe. The other big thing about the Vallow case, so Nate Eaton and Nate Eaton specifically, but he's a great source to follow. He's one of my main squeezes on the Vallow case. But East Idaho News with Nate Eaton and also Justin Lim, they will be allowed to they'll be the pool camera for this trial. So that was settled. And it's great because that means then we'll all be able to see and hear what goes on in court. The other issue about like us seeing what goes on in court was Lori Hellis, who is a retired attorney who had practiced, I believe, in Nevada and I think Colorado, Oregon, maybe Idaho as well. She's retired now though, so she's inactive, but she wrote a motion to unseal some of the court's dealings, because when stuff happens in court, usually the public sees it because it happened. Gag orders are when you can't talk outside, like lawyers can't talk about the case to anybody else outside of court, but everything that happens in the court is public knowledge, and we have that because of transparency. But a lot of things in this case have been sealed. Some of it because of Lori's health issues, and those are still like HIPAA things. But also, I believe in these high visibility cases that when they're national news or international news, as this case is, until there's a jury picked, they don't want things known. And so Lori Hellis was writing a book, and she is a contributor to the Hidden True Crime podcast, which I recommend as a main squeeze source for the Vallow-Daybell case. They've been following along. There's a journalist, Lauren Matthias, and her husband, who is a psychologist. He's actually a criminal psychologist who does a lot of testing in jails, I believe, and goes to court. He's one of those people that helps. I don't know if he works for what type of side he works for, but they've been doing a podcast, Hidden True Crime, as well as a YouTube channel then simultaneously. I recommend it. It's very interesting. And when I recommend a main screen source, it doesn't mean I agree with every single thing that comes out of their mouth. Please understand. It's just that in like the majority of things, I highly recommend, especially the Friday Night Lives with Lori Hellis, because Lori is a lawyer and she and Lauren talk about this case and really ask and answer a lot of the questions we all want to know about why is this happening this way and what does this really mean and what does this indicate. So Lori Hellis, she is also on Twitter, and she has a news letter type thing online. Sign up for it, get it, you will love it. So anyways, so she wrote to the court and wanted to intervene. So in court parlance, court talk, that means that she wants to enter into the case as an interested party. She wants to intervene, and she was asking for things to be unsealed for the public knowledge and good, and as a writer, because she's writing a book about this, so as a journalist. And she cited free speech, and she cited transparency in the law, and the sunshine laws, and the right to know, which aren't as strong in, like, weirdly, Florida has very strong sunshine cases, very interestingly. So, whereas I don't think Idaho does. So, but first you have to ask, like, you have to intervene, you have to be granted what is called standing. And I wondered about this, and so this week we found out that Judge Boyce basically wrote back to Lori Hellis, addressed her motion in writing, and basically said, nope, 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 and nope. Yeah, and basically he said she has no standing to intervene in this case, and that she would have to, and he gave her parameters to meet. So just recently on Twitter, I saw that Lori Hellis, it's go time. She took a picture. She's got a whole stack of documents. She is responding. She's a very good lawyer. So Judge Boyce is going to have a little fight on his hands, and he might have to. I mean, I think what he's trying to do is keep the jury pool non-tainted. So. But Lori Hellis makes great arguments. Scott Reich, who, like I said, is a libertarian defense attorney, he's all in for Lori Hellis, getting us that information. And we're going to be talking about another case that Scott Reich actually said something about, which I didn't think I think he missed one ruling on that. But he's a great follow, too. So anyways, and he's in Colorado. So all these people out west are right there following this case, and they're lawyers. I highly recommend listening to them to get a really well-rounded perspective. So that's Scott Reich on the Crime Talk YouTube channel, and Lori Hellis, who is a contributor on the Hidden True Crime channel. So that's where you can find more about that. So we don't know what Lori's attorneys will get in the way of how the challenging how how the indictment was written. Does it go back to a grand jury for a cure? Is this problem cured by jury instructions? We will wait for Boyce to tell us. I mean, even though it would be a pain, the basic problem would be that this is supposed to go to court in January 9th. And if they have to send it back to a grand jury and present all the evidence again, they can't just like rewrite it, I guess. That might put us back. But it just seems like trials keep getting put off. We have a lot of trials that just keep putting back. In fact, we have the Aiden, what's his last name? Fucci? Who is alleged to have killed teen in his middle school, Tristan, who was a cheerleader. His case is now pushed back again, and then another case was pushed back. The Pike County Massacre. Maybe they're making a deal, but George Wagner the fourth, his case that was supposed to be happening in August was pushed back until October, November. That might be due to Ohio. The AG who filed the case and fought the case against the Wagners was Mike DeWine, who is the governor now, and he's having a tough race right now in Ohio. And I don't know if anybody's helping out anybody, but, you know, him saying, I was tough on crime, see, look, I'm, you know, the people I put away are, you know, right before November. Does that help him? Maybe. I don't know. You'd like to think that law enforcement and like the whole legal system in a state wouldn't do that, but unfortunately we know things can happen that way. So anyways, we will find out if the prosecutors have to send everything back to a grand jury. I don't think there'd be a problem. It would just delay the case. We're going to find out when Lori Hellis, she's refiling, and we're going to see if Judge Boyce says she has standing, which means standing means you're allowed to intervene in a case. It means you're allowed to speak. And she is speaking for people who want to know. So that will be very interesting. The consumptive testing. So last week, my two little court cases on Vallow and Murdaugh didn't get into the podcast, and there's already new stuff. So I just didn't even upload those two little things. But yes. We do know that the consumptive testing question was fixed outside of court. The two sides agreed. And so what it looks like now is that the consumptive testing, if there's enough, the state will go ahead and do their testing and give the excess to the defense. If there's a problem with limited, they will talk to the defense and they will work out an issue at that time. So they agreed upon this. Now it's done. It's not part of court anymore. We won't hear about that unless it becomes an issue, I guess. So that is it for the Vallow case. Like and subscribe. Thank you.